Lebene Konan sued the Euless, Texas post office for what she claimed was their intentional failure to deliver mail to rental property she owned. The Supreme Court just said she didn't have the right to sue. So we'll discuss this next on the Constitution Study.
Loving neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach your rising generation to be free. Glad you could join me today. It's an interesting case. It involves something that really gets under my skin. We'll talk more about that later. There's some good stuff in here, even if the case itself is pretty short and brief. Now, if you want to find out more, if you want to follow along, head to the website, constitutionstudy.com. You can find the article with links to all my sources. With that, I'll talk more about the website at the end, but for now, let's take a look at this case. The case started with a beef between an individual and their local post office. Respondent Lebene Konan and the local post office in Euless, Texas, had an extended dispute concerning mail delivery to two rental properties owned by Konan. The dispute basically came down to who owned the property and who was eligible to receive mail at the two addresses owned by Ms. Konan. According to Ms. Konan, how the U.S. Postal Service handled the complaint led to serious consequences for her and her tenants. As a result, Konan and her tenants did not receive important mail. Konan resorted to private carriers. The disruption in mail service resulted in the loss of tenants and made it more difficult for Konan to attract new tenants. The carrier also taped a red notice inside the mailbox stating that mail addressed to some but not all of the Saratoga residents could be delivered to the box. In 2021, postal workers also allegedly stopped delivering mail to the Trenton house after discovering Konan owned it as well. Ms. Konan did what most people would do. She filed a complaint with the Postal Service. However, that did not get her the results she wanted. After administrative complaints proved unsuccessful, Konan sued the United States in federal court, bringing various state law tort claims alleging that the United States Postal Service intentionally and wrongfully withheld her mail. As with most federal suits, the first stop was a district court. The district court dismissed Konan's complaint pursuant to the Federal Tort Claims Act's postal exception, under which the United States retains sovereign immunity for all claims arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. The district court claimed the United States has sovereign immunity. I'll cover that more in a later chapter. The court also noted that Congress provided that the ability to sue did not include cases involving the non-delivery of mail. The provisions of this chapter and Section 1346B of this title shall not apply to any claim arising out of loss, miscarriage, or negligent transmission of letters or postal matter. Don't you love it when the government writes laws exempting itself from its own negligence? Now, the Fifth Circuit Court of Appeals disagreed. The Fifth Circuit reversed, holding that the terms loss, miscarriage, and negligent transmission do not encompass the intentional act of not delivering the mail at all. The Fifth Circuit apparently thinks that negligent acts are not intentional. However, the Fifth Circuit disagreed with the First and Second Circuits, which led to the Supreme Court case. In contrast, the First and Second Circuits have interpreted the postal exception to apply to suits even when they arise from harms caused by intentional misconduct. The court granted certiorari to resolve the split. So, how did the Supreme Court view this case? Well, they held the United States retains sovereign immunity for claims arising out of the intentional non-delivery of mail because both miscarriage and loss of mail under FTC's postal exception can occur as a result of the Postal Service's intentional failure to deliver the mail. Well, there are a couple constitutional issues with this decision. The first problem with the decision is the idea of federal sovereign immunity. As Justice Thomas wrote in the opinion, the United States retains sovereign immunity. But in order to retain sovereign immunity, the United States must have it in the first place. As the Free Legal Dictionary states, in the United States, the sovereignty resides in the body of the people. And since the Constitution does not delegate to the United States sovereign immunity, that power remains with we the people. So without sovereign immunity, what claim does the United States have that they are immune from suit? As I pointed out, the district and Supreme Courts point not only to the myth of sovereign immunity, but to federal law, specifically 28 U.S.C. section 2680B, which reads, "The provisions of this chapter in section 1346B of this title shall not apply to any claim arising out of the loss, miscarriage, or negligent transmission of letters or postal matter." Now, this section is a part of the chapter on jurisdictions and venue, and section 1346B states, "Subject to the provisions of Chapter 171 of this title, the district courts, together with the United States District Court for the District of the Canal Zone and the District Court for the Virgin Islands, shall have exclusive jurisdiction of civil matters on claims against the United States for money damages accruing on or after January 1st, 1945, for injury or loss of property or personal injury or death caused by the negligent or wrongful act or omission of any employee of the government while acting within the scope of the office or employment under circumstances where the United States, if a private person, would be liable to the claimant in accordance with the law of the place where the act or omission occurred." So Congress says we can sue in federal court for loss, injury, or death caused by the negligent or wrongful acts of a federal employee. That is, except for the negligent transmission of postal matter, section 2680B. But that violates the First Amendment, which reads, "Congress shall make no law abridging the right of the people to petition the government for a redress of grievances," which is exactly what section 2680B claims to do. Abridge your right to petition the government for a redress of grievance. In this case, Ms. Konan has petitioned the government for a redress of a grievance she has with government employees, specifically the actions of postal employees. But two of the three federal courts claim that a law of the United States that was made not pursuant to the Constitution supersedes the plain language of the supreme law of the land. Now, how does that make you feel? The fact that, according to the Supreme Court, not only the Postal Service, but the federal government itself is immune from the consequences of their actions. And just where does the United States get such immunity? Not from the Constitution, but from a court, a group of justices in black robes. Doesn't that sound like grievance number 15 of the Declaration of Independence? For protecting them by a mock trial from punishment for any murders which they should commit on the inhabitants of these states. After all, the preamble of the Constitution states, "We, the people of the United States, do ordain and establish this Constitution for the United States of America." In other words, we created the federal government, including the Supreme Court. We gave this government limited and enumerated powers. We confirmed the limitation of the federal government in the 10th Amendment, which reads, "The powers not delegated to the United States by the Constitution, nor prohibited by to the states, are reserved to the states respectively or to the people." Where does the Supreme Court, where does Justice Thomas get the gall to claim that the federal government is sovereign over its creator? If we, the people, ordain and establish the Constitution that created the federal government, why do we cower under its tyranny? Since the states are the ones that ratified the Constitution that created the federal government, why are they letting their creation run amok? Could it be that the sacred fire of liberty George Washington talked about has gone out? As he said, "And since the preservation of the sacred fire of liberty and the destiny of the Republican model of government are justly considered as deeply, perhaps as finally staked on the experiment entrusted to the hands of the American people." See, to me, this case is not so much about the Postal Service or their bad actions or even whether or not you can sue them. It's this very concept of sovereign immunity, that the creation is greater than its creator, that the federal government created by the people and the states somehow lords over it and cannot be held accountable for their bad actions. That, ladies and gentlemen, is not just a violation of the Constitution. It is a violation of the Republican form of government. It's a violation of the very premise that we, the people, are sovereign, that we establish governments to protect our rights. That can't happen if they are allowed to violate our rights with immunity. So this, ladies and gentlemen, shows how twisted the courts have taken the Constitution and how much of an impact it has on we the people. Will we stand for it? Or will we stand up and say, "No, you're not authorized to do that. I don't care what the court says. The court is not perfect. The court is not the sovereign. We the people are sovereign. We said you don't have that power. And when the courts get it wrong, it's time to do something." Maybe it's time to start impeaching some justices, including Justice Thomas, because this is a violation of their oath of office, which is bad behavior, which is the violation of the oath, but it also is, remember Article 3 judges serve the Supreme and Inferior Courts during their good behavior. This is bad behavior, folks. I don't care who appointed him. I don't care the politics. This, ladies and gentlemen, is bad behavior by a majority of the justices, and it should be called out as such. Who knows? Will anybody join me? Or will I be the one standing out in the wilderness shouting this truth alone? Now, if you want to find out more, of course, head to the website, constitutionstudy.com. Find this article, find all my articles, find the videos, find my news feeds, sign up for a mailing list. There's plenty of content there. Of course, you can also go to the store and support the work that we're doing, something by buying a book or a shirt or a mug or just donating to the cause. See, nobody gets paid here. We do this voluntarily. We pay to put this on. So anything you can do to help us is greatly appreciated. Of course, you can also support the work that we're doing here with your cell phone. That's right. Patriot Mobile is America's only Christian conservative wireless provider. I joined them several years ago because, well, they take a portion of every dollar and support organizations that are defending your rights. Now, the Constitution Study is an affiliate, which means if you go to patriotmobile.com/constitution, find a plan that works for you and sign up, every time you pay your cell phone bill, you're helping to support the work that we're doing here. Guess what? You can also get a discount. Everyone from veterans and first responders to families with multiple lines are eligible for discounts. And if you use the promo code Constitution at checkout, you'll get your new line activated absolutely free. So join me not only in America's only Christian conservative wireless provider, but in supporting groups and organizations that are defending our rights by going to patriotmobile.com/constitution, finding a plan that works for you, and joining us in using our cell phones to defend our rights. Now, I also hope that you'll come back and join us here next time we meet for the Constitution Study.